Hello students, and welcome back to Political Science 1513.W1, American Federal Government Online. Once again, I am your instructor, Connor Alford, and this week we're going to begin our discussion of the judicial branch. Towards that end, we do have 8 learning objectives, and we'll go over these at this time. So number 1, summarize the main function of the judicial branch. Number 2, explain the concept and the significance of judicial review. Number 3, describe how the judicial branch is structured. Number 4, distinguish between the main types of jurisdiction and the different courts that hold each type of jurisdiction. Number 5, pick out examples of cases that would be heard under appellate versus original jurisdiction, as well as examples of cases that would be heard in state rather than federal jurisdiction. Number 6, describe the procedures of the United States Supreme Court. Number 7, identify the main factors influencing how justices rule, and describe the main forms of jurisprudence, constitutional interpretation, and other such factors. Finally, we're going to close with learning objective number 8, where you are asked to describe the various ways in which the judicial branch can be held accountable by the other branches through our system of checks and balances. Let's go ahead and get started with the first learning objective. So do recall from prior lecture that the judicial branch is that organ of our federal government constitutionally vested with the power and duty of adjudicating the law. To adjudicate is to act as a judge, or, in other words, to resolve disputes about how to interpret and apply the law to particular cases. It is important to understand that while the legislative branch is the portion of our federal government responsible for creating the laws, it doesn't really have the capacity to write specialized laws for every imaginable set of circumstances that might emerge. And so when it comes to taking the general principles of legislation or of our Constitution and figuring out how to apply those in particular cases, we tend to rely very heavily on the courts. And the courts, of course, you will understand, are together what we call the judicial branch. So the judicial branch is made up of the various courts in our country, and its job under our Constitution is to resolve disputes about the law. It serves as a sort of theoretically neutral mediator when we have disagreements about how the law applies in particular cases. But it is important to understand that in order to resolve disputes about the law, you must first interpret that law so that you can figure out what it does and does not say. And you need people to respect your interpretation of the law, because if they don't, then your rulings aren't really going to be all that meaningful. So the judicial branch is very powerful, and it's very powerful because it has the power and authority to interpret the law and to have other actors in government, including the legislative and executive branch, generally bound by those interpretations, even if they're not necessarily carried out in good faith. Now, this function of interpretation is especially important when we start talking about constitutional disputes, because remember that the Constitution is a system of laws for the lawmakers. In other words, the Constitution is itself subject to interpretation by the courts. Now, it's worth noting that this was not necessarily intended by the framers, although some of them probably would have liked the idea that the courts do have this power to interpret the Constitution. Nevertheless, what you're going to find is that the power of the court to interpret the Constitution and to resolve disputes about the constitutionality of government actions is what we call judicial review. Again, judicial review is the power of the courts to resolve disputes about the constitutionality of government actions, and that in turn requires that the courts have the power to interpret the Constitution. However, I want you to understand that the term judicial review is nowhere to be found in the Constitution, and it's not really going to emerge until about 1803 when we get the United States Supreme Court ruling of Marbury versus Madison. There's a lot that we could say about this case, but most of that's covered by your textbook, so for the purpose of lecture, here's what I want you to understand. In the case of Marbury versus Madison, the Supreme Court of the United States gave itself the power of judicial review, the power to resolve disputes about the constitutionality of a law or other government action. Now, this is especially important for 2 major reasons. First, this makes the courts extremely powerful, and many have argued that today they're the most powerful portion of our federal government. Because you have to recall from our earlier lecture that the Constitution of the United States is the supreme law of the land that everybody, including our president and our congresspersons, happen to be bound by. That means that anytime any actor in our government does something unconstitutional, they've broken the law and ought to be held accountable. But now the supreme law of the land is subject to court interpretation. So while we like to say that the Constitution is the supreme law of the land, and while that is true in theory, in practice it would be more accurate to claim that the supreme law of the land is the Constitution as interpreted by the courts. So again, through Marbury versus Madison, the judicial branch snatched a great deal of power and authority for itself, elevating itself to arguably the strongest portion of our federal government. Now, that wasn't necessarily intended, but that is a reality that we do need to acknowledge in order to understand how politics works today. In addition to this, judicial review is important because that's the primary tool by which the court engages in what we call judicial activism. And we're going to elaborate on this concept later in lecture, but what I want you to know for right now is that judicial activism is when the court plays an active role in not just resolving disputes about the law, but actually shaping the law and checking other branches of government. That wouldn't really be possible without judicial review, for reasons that I hope will become evident to you before the end of this video. Alright, let's move on and begin talking about the way in which our judicial branch is structured. So now we know what it does, but we need to talk about its organization. And as with any branch of the government, when we're looking for outlines or organizational blueprints, it's usually helpful to start by looking at the Articles of the Constitution, the main body that was drafted during the Constitutional Convention. And in particular, if we're interested in the judicial branch, we need to look at Article 3. However, I do want you to understand, and you can check this on your own, but Article 3 is really brief, and it doesn't provide us a great deal of detail. Article 3 does tell us that there will be one Supreme Court, and it authorizes Congress to create lower courts at its own discretion. It also tells us that the Supreme Court will have original jurisdiction in a number of very particular cases, and appellate jurisdiction in all other cases, with such exceptions as Congress shall make. Now, don't worry about the distinction between original and appellate jurisdiction just yet. We'll get into that. But what I do want you to understand is that the third article doesn't tell us very much about what sorts of courts Congress ought to create and what sorts of courts it ought not create. It doesn't tell us very much about how the judicial branch as a whole should be structured. And indeed, it doesn't really tell us all that much about the Supreme Court. It says there will be a Supreme Court, that it will have the judicial power, but it does not tell us how many justices should serve on that court, and it does not tell us how they should conduct day-to-day business. Do note, however, that it does take steps to preserve the court's independence by specifying that all justices on the court will serve for life, provided good behavior, so they don't have to get reelected. It also describes the selection process. Under Article 3, justices on the Supreme Court are not elected by popular vote. Instead, they are going to be nominated by the President and confirmed by a majority vote in the Senate. The power of the Senate to block or confirm a presidential nominee is what we call advice and consent. But we've already discussed that in prior lecture. So for now, just understand that the judicial branch is created in our Constitution by Article 3, but that its exact layout is more or less left up to Congress's discretion, with a couple of very specific exceptions to this general rule. So how is the court system structured? Well, it's kind of structured a little arbitrarily, because remember that the Constitution doesn't provide a very clear game plan. Most of the court system today has been created by Congress over time on an ad hoc basis. In other words, they created new courts and court boundaries as the need arose without any clear or coherent plan. As a result, the judicial branch is extremely complicated and sometimes hard for students to wrap their mind around. However, there are two major organizational features that we can focus on for our purposes here. First, understand that we operate under a dual court system. A dual court system is a judicial structure employing independent court systems, one operating at the local level and the other operating at the national level. In other words, there are separate court systems for each state and a separate court system for the federal government. By and large, the states are going to handle disputes about state law, and the federal courts are going to handle disputes about federal law. But we'll get into that more again later on. For now, just understand that each state does have its own court system, and that these state courts are going to handle most disputes about the law. So, for example, Oklahoma has a court system, and it's going to handle disputes about Oklahoma law, but Texas has a separate court system, and it's going to handle disputes about Texas law, whereas the country as a whole has a federal court system, and it's going to handle disputes about federal law. In addition to the dual court system, it is important to understand that the second major organizational feature characterizing our judicial branch is its hierarchical structure. We have a three-tiered hierarchy, meaning that the different courts in our country are separated into one of three categories. At the bottom of this hierarchy, we have what are called trial courts or district courts. A trial court is a court which makes an initial assessment. In other words, it's the first court that you go to 99 times out of 100. When you have a dispute about the law, you very rarely start in the United States Supreme Court. Usually, you're going to go to a trial court. Trial courts are also called district courts because each one has jurisdiction over a relatively small area known as a district. Our country as a whole is organized into 94 districts, and each of these districts has its own district or trial court. The district or trial court is going to handle all disputes emerging within its area. So the 94th District Court will handle all disputes about the law that originate in the 94th District. But it will never handle disputes that emerge in the 1st District, or the 27th, or the 35th, or the 48th. And it's not going to handle any disputes that occur in the 93rd District. It will only handle disputes that originate in its own district, and it will pretty much always be the first one to handle those disputes. But in this three-tiered hierarchical system, if you don't like the ruling of a district or trial court, you can always appeal that decision to a higher court. You can go above their head. In which case, you're going to advance to the second step or tier in this three-tiered hierarchy. The second set of courts created by this hierarchical structure are what we call the courts of appeals, or circuit courts. They're called courts of appeals because they handle appeals. An appeal is a challenge to a lower court ruling. So if you don't like the ruling of a trial court, if you think they've done something wrong or violated your rights in some way, you can file an appeal, asking a higher court, a circuit court, to review that decision. And if the circuit court agrees with you, it has the power and authority to overturn the lower court's rulings. We call the courts of appeals circuit courts because each one has jurisdiction or authority over cases originating in one of 13 circuits. So if you wanted to see what the dual court system looks like, understand that this hierarchy is going to operate in Oklahoma, where we have 77 district courts, a number of courts of appeals, and a federal court. But then also understand that each of these courts of appeals or circuit courts is going to have jurisdiction or authority over cases limited to a particular portion of the country. So, for example, if you live in California, you're in the 9th Circuit. And what that means is that if, while you are in California, you decide to challenge a ruling of a district court in this area, you're going to take that challenge to the 9th Circuit. Another way to think about this is to understand that the 94 districts in our country are each organized into one of 13 circuits. And each of these 13 circuits is going to handle any appeal or challenge to a lower court ruling which originates within its territory. Do note, however, that the circuits are not equal in any way, shape, or form because their boundaries were drawn, again, as the need arose by Congress. So note, for example, that the 9th Circuit encompasses Washington, Oregon, California, Nevada, Arizona, Idaho, and Montana, as well as Alaska, Hawaii, Guam, and the Marshall Islands. So that's a great deal of territory which falls under the authority of the 9th Circuit. By comparison, the 10th Circuit is relatively small, encompassing Oklahoma, Kansas, Colorado, Wyoming, Utah, and New Mexico. These aren't very populous states, and that means that the 10th Circuit only hears a relatively small number of appeals as compared to, say, the 9th Circuit, where you've got a lot more people and therefore a lot more individual district courts and a lot more disputes about the law to process. But if you don't like the ruling of the circuit court, you're still not done, because you can always appeal one step further. The highest court in our country is the Supreme Court of the United States. And one thing that's important to keep in mind about the Supreme Court is that it's not only the only court actually mentioned by the Constitution, it's also the only court in our entire country with nationwide jurisdiction. Remember that if you look at the circuit courts, each one only has authority over a small area, whereas the Supreme Court's rulings apply across the country. If you live in the 10th Circuit, you're not bound by the decisions of the 9th Circuit. If you live in the Ninth Circuit, you're not bound by decisions made in the 10th Circuit, or the 5th, or the 11th, or the 8th, or the 7th. But regardless of where you live, all Americans are bound by the rulings of the United States Supreme Court. So, for example, before the United States Supreme Court weighed in on same-sex marriage, it had been legalized by a court ruling in the Ninth Circuit, meaning that people who lived in California or Washington or Idaho were able to marry same-sex partners. But the 10th Circuit hadn't issued a similar ruling, and so people in Oklahoma and Kansas, they didn't enjoy that same access to same-sex marriage. But once the United States Supreme Court issued its ruling legalizing gay marriage on a nationwide level, well, all Americans gained access to that ability to marry same-sex couples or partners under the law. So again, it's important to understand that we do have a three-tiered hierarchy. But when you look at this three-tiered hierarchy, and you also understand that we have a dual court system, you're going to begin to recognize that there are a whole bunch of different courts all across our country, and that they're all going to fulfill different functions. So if you yourself have a dispute about the law, the next obvious question that you might want to ask is, how do I figure out which court I'm supposed to go to? And the practical answer to this question is that you're going to be given instructions by either your attorney or an officer, so on and so forth. However, if you needed to figure it out on your own, there are some tools that we can use, and the first important distinction that you're going to need to make has to do with state versus federal jurisdiction. State courts have state jurisdiction, federal courts have federal jurisdiction. Remember that jurisdiction is the power and authority of a court to hear a case and issue a ruling which both parties are bound to follow. In other words, it's the ability to resolve a particular dispute about the law. Generally speaking, if you have a dispute about a state law, then you're under state jurisdiction, and therefore you will go to a state court. If you do not like the laws in Oklahoma, you're probably going to go to an Oklahoma court when you try to challenge them. If you get a speeding ticket in Durant, Oklahoma, you will probably go to a state district court in Calera, Oklahoma, which is very, very close to our city. But you're not going to go to a court in Calera if you have a dispute about a Texas law or if you have a dispute about a federal law. If your dispute is about a federal law, you're probably going to go to a federal court. So, generally speaking, when you're trying to figure out, do I need to go to a state court or a federal court, the first question you need to ask yourself is whether or not you have a federal question. A federal question is a dispute about a federal law. That law could be the Constitution of the United States, it could be an act of Congress, it could be a treaty, or it could be an executive order. But if it's created at the federal rather than the state level, then it's under federal jurisdiction because you have a federal question that the states aren't able to answer. But even if you don't have a federal question, there are a couple of other avenues to federal courts. So if you don't have a federal question, the next thing you need to ask yourself is whether you have a diversity of citizenship. A diversity of citizenship is when a dispute about the law involves parties from different states. For example, if an Oklahoman wanted to sue a Texas businessman, then the Oklahoman would not want to go to a Texas court because the Texan court might provide preferential treatment to the Texan. But on the flip side, the Texan probably wouldn't want to go to an Oklahoma court because the Oklahoma court might provide preferential treatment to the Okie. To ensure that the courts are a neutral mediator, when we have a diversity of citizenship, the case is brought not to state court but to federal court, even if there is no federal question. The same can be said when we have lawsuits between states. So, for example, both Oklahoma and Nebraska have recently sued Colorado over its marijuana policy, and Colorado wouldn't tolerate that case being brought to an Oklahoma court because the Oklahoma court's obviously going to rule in Oklahoma's favor. Similarly, Oklahoma doesn't want that to be heard in a Colorado court because the Colorado court has a dog in the fight. It's biased. It's not neutral. So again, to provide a neutral mediator, when we have a diversity of citizenship or a state question or a state versus state lawsuit, we go to federal courts. But if we don't have either of those, the only other way is to have a federal question. Bottom line then, if you have a federal question or a diversity of citizenship or a lawsuit between states, you go to federal court. If you do not have a federal question and you do not have a diversity of citizenship and you do not have a state versus state lawsuit, then you go to a state court. To get to federal court, you only need to answer yes to one of these conditions. But even once you've figured out whether you belong to state or federal court, you're going to have to decide whether you should go to a district court, a court of appeals, or to the Supreme Court of the United States. Now, I've already told you that in 99 out of 100 cases, you're going to start in a district court, and that's still true. But what I want you to understand is that the reason you usually start in a district court is that district courts hold what we call original jurisdiction. Original jurisdiction is the authority or the power of a court to make an initial ruling and hear a case that has not been previously considered. If you don't know, a case is just a dispute about the law that has been brought before a court. And when you have original jurisdiction, that means that you get to be the first person to hear the arguments of both sides in that case or dispute, and you get to be the first person to issue a ruling resolving that dispute. But again, if you don't like the decision made by whichever court had original jurisdiction, usually a trial court, then you can appeal and take that to a circuit court. While district courts have original jurisdiction, they do not have appellate jurisdiction. Courts of appeals, or circuit courts, are the opposite. They have no original jurisdiction, meaning that you never start in a circuit court. But they do have appellate jurisdiction, meaning that they can review and either uphold or overturn a prior decision by a lower court. So appellate jurisdiction is the power to reevaluate and either uphold or overturn lower court rulings. Do note that I would like to emphasize the lower court component of this. The circuit courts do have the power and authority to overturn rulings issued by district courts, but they do not have the power to review and either overturn or uphold Supreme Court rulings. The Supreme Court is at the top of this three-tiered hierarchy, as we've already established. But there's one peculiar characteristic that you ought to understand, and that's quite simply this. The Supreme Court of the United States, or SCOTUS, is the only court in our country at the federal level which has both original and appellate jurisdiction. That means that in certain cases it can issue an initial ruling, but that's relatively rare. In most cases, when the Supreme Court gets to have a say, that's because the case has already gone through district and courts of appeals. So 99 out of every 100 cases that make it to the Supreme Court are going to be heard by the Supreme Court on appeal. But the Constitution does provide a relatively small number of cases that can begin in the Supreme Court if it chooses to hear them. The original jurisdiction of the Supreme Court is extremely limited, but it is constitutionally protected, whereas the appellate jurisdiction of the Supreme Court is very broad, but subject to rules and regulations or exceptions as Congress shall make. So let's talk a little bit about that Supreme Court of the United States of America, because what we're going to find is that within the broader mission of resolving disputes about the law, the Supreme Court fulfills a special function. In specific, the Supreme Court of the United States of America has two primary missions that operate within the broader function of the judicial branch as a whole. First, it provides national uniformity of the law. Remember what I told you. The Supreme Court of the United States is the only court in our country which establishes rules or precedents that are binding to all Americans regardless of which part of the country they live in. Whether you're in California or New York, Oklahoma, or Washington, you do fall under the authority of the United States Supreme Court. However, if you live in Oklahoma, you're not under the authority of the Circuit Court in the 9th Circuit, and if you live in California, you're not under the 10th Circuit Court's authority either. So, in some cases, we will have what's called a circuit split. A circuit split is a disagreement about how to interpret and apply the law that emerges when two circuit courts come to contradictory conclusions. For example, if the 9th Circuit Court says that there is a constitutional right to same-sex marriage, but the 10th Circuit Court says, no, there is not, we have a circuit split, a disagreement about the law which exists between different courts. And neither the 9th Circuit nor the 10th Circuit has the authority to overturn the other's ruling. Because remember that appellate jurisdiction only lets you review and overturn lower court decisions, and the 9th Circuit is not lower than the 10th Circuit, neither is the 10th Circuit lower than the 9th Circuit. But both the 9th and 10th Circuits are lower than the United States Supreme Court, and therefore the United States Supreme Court is the only court in our country that can resolve such a dispute. Similarly, when the United States Supreme Court issues its rulings, it provides what we call an opinion of the court. An opinion of the court is a written publication detailing how the court has ruled and providing an explanation of the constitutional reasoning that justifies this decision. These opinions then act as instructions for all other courts and government actors about how they should interpret the law. So if the Supreme Court says that there is a constitutional right to same-sex marriage, then every other court in the country has to assume that's true, even if they just don't see it in their own reading. The Supreme Court of the United States also makes final decisions. In other words, it's the last resolution. You can't appeal above the United States Supreme Court. Now, it is worth noting that the Supreme Court can, and in some rare circumstances has, overturned its own decisions in the past. But by and large, the only way to overturn a Supreme Court case ruling, other than getting the court to decide that it made a mistake, is to amend the Constitution. And that's not particularly easy. But let's talk for just a moment about how the Supreme Court is structured. And remember that there's not very much in the Constitution on this topic. I've already told you how they're nominated, and I've already told you that they serve for life terms. When you read the Federalist Paper 78 essay for our assessment, you'll understand why these provisions were included. But today, the Supreme Court of the United States is structured to include 8 associate justices and 1 chief justice. Understand the Chief Justice is not technically any more powerful than any other justice, but he does get to decide which of the justices write the opinions of the court when it's time for those to be published. Other than that, what we're going to find is that the Chief Justice is basically identical in overall power and authority to every other justice on the court. Now, remember that there's nothing in the Constitution which says we have to have 9 justices. We do, but that was determined by Congress. Everything else is going to be subject to variation. How does the court fulfill its special functions? Well, again, it does this by issuing opinions. Those opinions tell the world how it has resolved a dispute in an authoritative manner and provide instructions to other government actors about how to resolve similar disputes so that we come to similar rulings across the country in time, rather than having a whole bunch of conflicting decisions being made by different courts in different places at different times. But I do want you to understand that the court cannot issue an opinion on a case that it has never heard, and there are certain limitations to the types of cases that it is allowed to hear. So Article 3, Section 2, Clause 2 of the Constitution does tell us again that the Supreme Court has original jurisdiction over certain cases, but those are relatively rare. For example, one type of case that the Supreme Court has original jurisdiction over is a dispute involving a U.S. or foreign ambassador. Another type of case over which the Supreme Court has original jurisdiction is a lawsuit emerging on international waters. But these types of dispute are really, really rare, and the list of cases in the Constitution where the Supreme Court has original jurisdiction is very short. So most of its cases are going to be heard on appellate jurisdiction, because the Constitution tells us that while the Supreme Court only has original jurisdiction in a certain number of specifically enumerated case types, it will also have appellate jurisdiction in all other cases with such exceptions and regulations as Congress shall provide. Do understand that this means that Congress does have the power to strip the court of its appellate jurisdiction, and there have been a couple of cases throughout United States history in which the court has done this as a way of checking the court's power. Congress can use what we call jurisdiction stripping when it uses this constitutional provision to limit the authority of the court to hear certain types of cases, and this was an intentional design put into the Constitution to allow Congress to fight back if the courts became overly activist. Now, that being said, understand that historically speaking, Congress has given the Supreme Court of the United States a great deal of deference, meaning that its appellate jurisdiction is subject to very few rules and regulations, and that for all practical purposes, the Supreme Court can hear pretty much whatever cases it wants, as long as it hears them on appeal. Of course, just because the Supreme Court can hear a case under the Constitution doesn't mean that it's going to do so. In fact, of every 4,000 cases that the Supreme Court would be allowed to hear if it wanted to, it's only going to accept about one of those cases. There are certain types of cases that it's more likely to accept, and most of these have something to do with its core constitutional duty of providing a final say and maintaining the uniformity of laws across our country. So first, what we're going to find is that when there's a circuit split or a disagreement between courts at lower levels about how to interpret and apply the law, well, the Supreme Court's more likely to weigh in order to help resolve these problems because it's the only one who can. The Supreme Court is also more likely to accept a case in which a lower court has issued a ruling incompatible with a prior decision that the Supreme Court has already made. Finally, the Supreme Court is more likely to accept cases when there's a major controversy and everybody in the general public expects them to do so. Some recent examples of this include the Supreme Court's decision to weigh in on Obamacare and the Supreme Court's decision to weigh in on same-sex marriage. Although the same-sex marriage issue also provides an example of the court accepting a case in which we observe a circuit split or a disagreement between lower courts. One way or the other, these are the types of cases that the court prefers to hear. They're not the only type of cases that it accepts, but most of the time, if you don't fall into one of these three categories, your odds of getting to the Supreme Court are extremely low. In addition to these general preferences, the Supreme Court has established some of its own informal rules about what types of cases it can and cannot hear. And the most important thing to understand is that the court will only hear cases involving a litigant with standing, and those only occur when we have what is referred to in the legal community as either a case in controversy or, to use the language of your textbook, a justiciable controversy. A justiciable controversy or a case in controversy is basically just a legal dispute involving a real law and a substantial disagreement over an issue where at least one party has actually been injured in some way, shape, or form. In other words, again, you have a justiciable controversy anytime there is a litigant with standing. But what does that mean? Well, first, let's break down the term litigant. A litigant is anyone taking a legal action. If you file a complaint with a court and you ask that court to help mediate a dispute about the law, you're automatically a litigant. But not every litigant gets to have his day in court. In order to get a day in court, you must first establish standing. Standing is the right to have your dispute heard in a court of law. And what we're going to find is that in order to establish standing, you've got to satisfy a couple of core conditions. First, you need to establish that you have been injured in some way, shape, or form. Understand that you have to have already been injured. The court does not, under any circumstances, accept hypothetical cases or issue advisory opinions. If there's not a case in controversy where a litigant who has the right to be heard in court has actually already been hurt by an existing policy, the court's not going to agree to hear that argument. So you need to show that there is a current law that is already passed and that you have already been affected in some kind of a negative way by that law. Now, your injury does not have to be physical. It can be physical. If the government creates a law that results in your leg getting broken, you might want to sue the government for compensation. But you can also challenge decisions made by, say, your state or by the federal Congress if you feel that they have injured you in an insubstantial way, or I should say a non-physical manner, by, say, violating your rights or by denying you equal protection of the law. In these cases, you've been injured, not physically, but legally. The second condition is that the injury has to be meaningful or substantial. In other words, it has to be something above and beyond, I've been offended, my feelings have been hurt, or I've been mildly inconvenienced. You have to show that some core constitutional right has been violated or that your life has been disrupted in some kind of a meaningful way. If you cannot do this, then you do not have standing. Do understand that all of this means that, by and large, you cannot sue on somebody else's behalf. Now, the exception to that general rule is that sometimes parents can sue on their children's behalf, and that if somebody has given you power of attorney, then maybe you can act on their behalf, but those exceptions are exceptionally rare, and I don't want you to focus on them at this time. Just understand that to have standing, you have to have been the party injured, and the injury you have suffered has to have been substantial. If neither of these are true, or if either of these is false, then you do not have standing and your case will not be heard by the court. Let's say, however, that you do have standing and that you are under the jurisdiction of the Supreme Court. So you've gone through the district court, you appealed that to a court of appeals, and now you're asking the Supreme Court to hear your case and issue an opinion to resolve the dispute about the law that you're putting forward. Well, if that's the approach you've taken, then great. Now, again, do keep in mind that the court doesn't have to accept your case, but let's assume for the sake of argument that it's going to. What does this process look like? Well, the first step in the process is for the court to issue what we call a writ of certiorari. That's a W-R-I-T of S-E-R-T-I-O-R-A-R-I, a writ of certiorari. And that's basically just a fancy, unnecessarily Latin term, meaning invitation to be heard by the court. So a writ of certiorari is a written invitation asking you to bring your case or dispute to be heard before the Supreme Court. And in order to grant a writ of certiorari, the court has established that it must satisfy what we call the Rule of Four. There's nothing in the Constitution requiring them to do this. It's a convention that they've established for themselves, but it basically means that they will never hear or agree to accept a case unless at least 4 of the 9 justices say that they would like to do so. If you can't get at least 4 justices to agree to hear your cases, you're not going to get a writ of certiorari for those cases, and therefore you've failed to progress to the second stage. But if you do get the writ of certiorari, the next step is for the clerks to do their research. A clerk is basically a helper for the judge, and they're the ones who are going to gather all of the relevant facts about the case, and they're going to summarize these for the justices that they happen to work for. Each justice has a certain number of clerks. It varies from one justice to the next. Ginsburg happens to have a lot of clerks. Clarence Thomas only has a couple. And what we're going to find is that the clerks are going to read not only the procedural history and the arguments of the attorneys on each side, but they're also going to read what we call amicus briefs. Now, again, that term sounds scary, but an amicus brief, A-M-I-C-U-S, is going to be a friend of the court brief. In other words, an amicus brief is an advisory opinion written by an interested third party. It is not legally binding, but the clerks and the justices they work for tend to take these briefs very seriously because these interested third parties do a lot of research and do their best to put together the most compelling arguments for each side of the case. So, for example, if we've got a case on abortion, you can bet that some pro-abortion groups like Planned Parenthood will write amicus briefs arguing for why the court should rule in favor of abortion rights. But you're also going to get amicus briefs written by organizations like AUL, or Americans United for Life, that are going to explain to the court why it should rule in a pro-life manner. And the courts are going to consider the arguments presented by both the pro-life and pro-choice sides of this debate because that gives them an opportunity to see the strongest arguments presented for each perspective and to consider those in their calculations. When the clerks have done their research and reported to the justices will take some time to review that research before we advance to the third stage, where each side engages in oral arguments. During oral arguments, the attorneys representing both sides will have a handful of minutes in order to present their cases and to answer any questions that the justices might have. Understand that today oral arguments are mostly a formality, and that by the time we get to this third stage, most of the justices probably have already made up their mind, and you can usually guess how they're going to rule based on the types of questions they ask. But traditions are important to the court, so we do still have oral arguments, even if nobody's likely to change their mind as a result of the oral arguments that they are presented with during this stage. After oral arguments, we progress to the fourth step in this 5-step process, where the court makes its decision. During this judicial decision phase, the courts have to satisfy what we call the Rule of 5 in order to overturn a prior court ruling, an act of Congress, or other government action. The Rule of 5 says that you need at least 5 justices to agree to overturn the lower court's ruling, the act of Congress, or the president, in order for that act to actually be ruled unconstitutional. If you cannot get at least 5 justices to rule against the lower court's decision or the government action, then that government action is upheld. What if we have one justice who recuses themselves, leaving only 8 justices on the bench? Well, in that case, you might come to a 4-4 tie, where 4 of the justices say that we should overturn the lower court ruling and 4 say that we should uphold it. In such a circumstance, they have not satisfied the rule of 5, and therefore the lower court's decision is upheld. Whether we have 8 acting justices or 9, you've got to get at least 5 of them to agree before you can overturn an act by any other government agent, including Congress, the president, or a lower court. Now, generally speaking, that's not going to be too difficult. Most decisions that the court makes are going to be a 9-0 unanimous choice. Not always. That varies certainly when we get into controversial issues, but on most of the cases, it's unanimous, and it's not really difficult to reach at least 5 justices if the courts are going to act. So what happens next? Well, we're going to finish this process with the publication of the court's opinion. Now, there are many different types of opinions that the different justices can sign off on, and those are going to be described by your textbook. So I would encourage you to take some time to look at those, because they'll probably appear in the pool of questions from which I will select the questions that you have to answer in your quiz and in our next exam. For now, just understand, again, that the opinion of the court provides a publication of its decision and the legal reasoning behind that ruling. But reading through opinions of the court does actually help to identify a major empirical puzzle that legal scholars and political scientists like myself have struggled with for a very long time. Remember that the courts, by and large, are there to help interpret and apply the law, and they're all operating under the same constitution. So you would think that they tend to come to similar decisions. And again, for non-controversial issues like trade rights or the transportation of goods on a train traveling across state lines, that's usually what happens. But when you start to get into politically and emotionally charged issues like gun rights, abortion, or same-sex marriage, things change quite abruptly, where we go from our typical 9-0 unanimous decisions to a 5-4 split, where you just barely overturn or uphold a particular policy. Why is it that even though all of the justices are operating under the same body of laws, they suddenly start to come to contradictory conclusions when it comes to cases that deal with issues they personally have strong feelings about? Well, because contrary to what the court might want you to believe, empirical research has very well established the fact that the law is not the only or even the most important factor explaining how justices rule when we're dealing with politically charged or partisan issues like abortion. Instead, what we're going to discover is that the ruling of a particular justice in a case is going to depend primarily on A, that justice's judicial philosophy or jurisprudence, and B, that justice's political ideology. What is a political ideology? A political ideology is a set of core values and general beliefs about the appropriate role of government as a whole. And you're going to find that most people, justices and non-justices alike, have some political ideology. In the United States, the majority of us are going to either be in the liberal camp or the conservative camp, although a substantial minority also fall into some other camps, including libertarianism and so on and so forth. With that being said, I do want you to understand that liberals tend to side with the federal government, and they tend to believe that we ought to prioritize equality over freedom, whereas conservatives tend to side with state governments and tend to prioritize freedom over equality. I am grossly oversimplifying because we'll have an entire week set aside for political ideologies in the future. But right now, what I do want you to understand is that conservative justices tend to uphold conservative policies and tend to be more willing to strike liberal policies. Liberal justices tend to uphold liberal policies and tend to be more willing to strike conservative decisions. Similarly, because the Republican Party tends to be conservative, if a law is signed under a conservative president, it's less likely to be stricken by a conservative justice like Clarence Thomas and more likely to be stricken by a liberal justice like Ginsburg. Conversely, Ginsburg tends to be quite reluctant to strike any policy signed by Democratic presidents like Barack Obama and very happy to strike policies signed by conservatives like Ronald Reagan. Clarence Thomas likes Ronald Reagan's laws, but he's more likely to rule against policies passed by Democratic presidents like Barack Obama. So, contrary to what the court would like people to believe, individual justices do take their personal values into consideration when they are deciding how to mediate disputes. So much, then, for the theoretically neutral mediators we've been told to expect. But I do not want to overstate the importance of political ideology, because while it is one of the two most important factors in predicting how a particular justice will rule, it's only one part of the broader equation. Just as important to the decision-making process is the justice's judicial philosophy. And judicial philosophy is a little bit distinct from what we call political ideology. A judicial philosophy, or jurisprudence, is the beliefs that a justice holds about the proper role of the court and the appropriate use of judicial review. So, whereas political ideology pertains to general beliefs about the government as a whole, judicial philosophy pertains to a justice's beliefs about the proper role of the court and the appropriate use of judicial review. Generally speaking, remember that there are two major categories of jurisprudence. The first and most traditional understanding of the court's function is what we call judicial restraint. Judicial restraint is a judicial philosophy maintaining that judges should be strictly restrained to their strictly constitutional role as mediators of disputes about the law. In other words, a judicial restraintist says that a justice should do his best to restrain the influence of his own personal political ideology, values, beliefs, or biases, and that you should use judicial review to strike any law which violates the Constitution, but that you should not rule a law unconstitutional unless it is, in fact, unconstitutional. What that means is that a justice that holds the judicial restraint jurisprudence is more likely to strike a policy with which he personally agrees because it is unconstitutional. Conversely, a judicial restraintist is also more likely to uphold a policy that he or she thinks is a bad idea, but recognizes is not inconsistent with the Constitution. By contrast, judicial activism is a jurisprudence which says that justices should use their power of judicial review to play an active role, not only in interpreting and applying the law, but actively shaping it for the betterment of the country based on their own individual beliefs and values. And they also believe that the justices should play an active role in checking other branches of the government. So a judicial activist is a justice who believes that the proper role of judicial review is to shape the laws of our land and to actively check other branches of government. Now, which of these you prefer is totally up to you, and I'm not going to tell you where to stand, but I do want you to understand one thing. Justices who have different jurisprudences do tend to come up with different ideas about how to properly interpret the Constitution. And so we're going to take some time to talk about these competing views on proper constitutional interpretation. And we're going to start with the strict construction approaches preferred by restraintist justices. And these tend to be most common, though not universally accepted by conservative justices. Now, I say that they're not universally accepted. I do want you to understand that some conservative justices do, in fact, take broad construction activist approaches, and vice versa. Some liberals tend to prefer restrained strict construction or strict interpretations of the Constitution, but there is definitely a correlation where conservatives prefer the strict construction restrained justice, whereas the leftists tend to prefer a more broad construction activist approach to the law. The first of the strict constructions or strict interpretations of the Constitution favored by restraintists is what we call literal meaning or textualism. Literal meaning or textualism basically tells us that the justice ought not consider anything beyond the letter of the law. In other words, there is an emphasis on interpreting the Constitution according to its literal meaning under the laws of the English language. So, if the Constitution says, literally speaking, that there is a right to keep and bear arms, it doesn't matter whether or not the justice likes that right. He or she simply has to uphold it. The individual justice is restrained to providing a strict construction of the Constitution according to the laws of the English language, which of course are totally above and beyond the control of the individual justice. Some justices, even on the restraintist side, however, say that this approach is a little bit too radical, and they prefer to emphasize what is called original meaning. The original meaning approach emphasizes the literal meaning of the Constitution, but instead of using our modern rules of English language and grammar, focuses on the literal meaning of the Constitution's language at the time that it was written. So we're going to interpret, say, the First Amendment freedom of the press based not upon what the term press means today, but upon what the term press meant in 1787 when that amendment was ratified by Congress. There are, again, some restraintists who think that this, too, is too radical. So the next strict construction approach we're going to talk about is original intent. Original intent says that you need to consider not just what the Constitution's language literally says, based either on the laws of the English language today or at the time that it was written, but on the reasoning behind including the various clauses of the Constitution. So, for example, the term press at the time that the Constitution was written referred to any media that was produced en masse by a literal printing press. And so if we took a very, 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 very strict approach to the original meaning interpretation, then we could not interpret the First Amendment freedom of the press to include modern forms of media like the internet or cable television. The original intentist, however, would point out that the reason that the framers included the freedom of the press was not because they had some strange fixation with that particular technology, but because they wanted to preserve the free expression of political ideas and to ensure that Americans have access to information that's critical of their government. And they would say that the intent then ought to be understood as broad enough to encompass not just literal printed media, but also more modern forms of media like the internet, television, or radio. So the original intent approach leaves a little bit more room for individual discretion on behalf of the justices, but it's still a restrained approach overall because they're not putting their own intentions into the Constitution. They're operating based on their understanding of the intent behind the Constitution at the time that it was written, and they need to be able to justify their arguments about the intent of the Constitution with reference to some form of substantial argument like historical materials. Finally, we have the approach of stare decisis, which is Latin for let the decision stand. Stare decisis is an approach to constitutional interpretation, which tells us that justices ought to interpret the Constitution through the lens of prior rulings. So if in the case of Griswold versus Connecticut, the court had ruled that there is a constitutionally protected right to privacy, well then in the case of Roe versus Wade, they simply have to accept and defer to that precedent or prior decision. Similarly, if in Plessy versus Ferguson, the court has decided that it is perfectly acceptable to racially segregate public schools, then the court has to acknowledge that it is not a violation of the Equal Protection Clause in all future cases. In other words, don't second guess yourself. Under stare decisis, all decisions are final, and those become the authoritative canon of information on how the Constitution ought to be interpreted. All of these approaches ultimately fall under the strict construction or restraintist approach to constitutional interpretation because they limit the ability of the individual justice to be an activist promoting his or her own views or values in terms of what they think is best for the country as a whole. But some justices, especially on the left, again prefer a broad construction or a broad interpretation of the Constitution. If strict constructionists say that the Constitution is a legal document, then broad constructionists say, no, it's not a legal document, it's a living, breathing organism, and we have to adapt our interpretation of its meaning to the circumstances or to changing realities. So there are going to be, by and large, three broad construction or activist approaches to interpreting the Constitution. Polling jurisdiction says that we ought to interpret the Constitution through the lens of successful policies around the world. In other words, if you take the polling jurisdiction approach, you need to interpret the Constitution in whatever way allows you to uphold laws that have been successful in other parts of the world or across the states, and you need to interpret the Constitution in whatever way allows you to cast down laws that have not been successful across the world or among the states. Now, how do we decide which policies have been successful and which policies haven't? That's left entirely up to the discretion of the individual justice. They will interpret the success or failure of particular policies based on their personal values, preferences, and expert judgment, and then they're going to use that to shape how the Constitution is carried out in our country by wielding the power of judicial review to strike policies they think are bad and uphold policies that they like. A related but distinctive broad construction approach to interpreting the Constitution is what we call instrumentalism or modernism. So this is the second broad construction approach. Instrumentalism, or modernism, says that we need to reinterpret the Constitution in light of changing realities on the ground, especially technological changes, and that if we do not adapt our interpretation of the Constitution in light of changing realities, it will not remain relevant to the people. So, for example, you might argue that when we wrote the constitutional protection for the press, it wasn't a particularly big threat to public order because the press was, again, limited to literally hand-printed articles and newspapers. But today, the press is very different, an instrumentalist might argue. It's a much bigger threat to the order of our society because of the internet and television and things like the advent of fake news. So an instrumentalist might decide, in light of these changing realities, to reinterpret the Constitution to allow for more stringent restrictions on the free flow of information because they might think that it is more valuable or useful or instrumental in the modern world. Alternatively, you might make a similar argument with the Second Amendment. And in fact, what we're going to find is that if you read the court's opinions on certain cases, the left-wing justices have done exactly that. They've made the argument that while it is clear that the Constitution does protect an individual freedom to keep and bear arms under its literal or original meaning or its original intent, as well as through stare decisis, that when the Constitution was written, the firearms in question were muskets, and today we have machine guns. So an instrumentalist approach might be to say, hey, look, I know that there is literally speaking a right to keep and bear arms, but that doesn't matter because it's not relevant to modern life, and we need to reinterpret the Constitution in a way that will allow us to restrict firearms so that the government can continue functioning in light of changing realities. Finally, we've got pragmatism. Pragmatism basically says that a justice ought to reinterpret the Constitution in whatever way suits his or her own desired outcome. So the justice will, based on his or her own values, beliefs, and ideas about what's best for the country, strike all laws that he or she doesn't like, regardless of whether they are strictly constitutional, and uphold all laws that they like, even if they are, strictly speaking, unconstitutional. By and large, then, a strict construction or restraintist approach to judicial review says that you should only strike laws as unconstitutional if they are unconstitutional. Whereas a broad construction says that if you don't like the law, then it maybe should be stricken even if it isn't strictly unconstitutional. There are some checks on the overall level of activism the court can engage in before other portions of the government start to fight back, however, and towards this end, it's important to understand that the courts do care a great deal about legitimacy and public opinion. They're the most popular branch of the federal government because they're generally seen as nonpartisan and non-political. Now, again, we know that empirically that's not true, but it is the public perception. The public, generally speaking, sees the court as above partisan politics and general arguments, and they tend to think that the court's going to focus primarily on the law. Once more, we know it's not true, but because we perceive it that way, we tend to place a great deal of trust and deference in the court, and it's extremely legitimate, which means that it can get away with a lot of things that other branches of the government probably couldn't. Now, you might ask yourself, why does the court care about its legitimacy? Why does the court care that it's the most popular branch of the government? Remember, justices don't have to get elected, and that once they are on the court, they serve for life terms. They can be impeached and removed in the same way that a president can be impeached and removed, but only if they've committed a particular crime. And even when they've done something that is arguably illegal, understand that impeaching and convicting a justice is extremely difficult and very rare. In fact, it's only happened once with Samuel Chase in 1805. But do keep in mind that the court does depend on other branches of the government in a number of important ways. In particular, it requires the cooperation of the executive branch in order to implement and enforce its decisions. They don't have a bureaucratic army of foot soldiers who can implement their decisions on the ground level the way that the executive bureaucracy does. And so that means that if they make a decision that's extremely wacky, the bureaucracy in the executive branch can check them by refusing to carry it out on the ground level. Similarly, they might issue a ruling that the president refuses to enforce. And because the president is the commander-in-chief, the court doesn't have an army, and so when they need somebody to enforce their decisions, that somebody's going to be the president. For example, President Eisenhower was the one to dispatch the troops to enforce the Supreme Court's ruling in Brown versus Board of Education. Conversely, President Andrew Jackson refused to implement the Supreme Court's ruling when it declared the Indian removal unconstitutional. The Indian removal happened in spite of the Supreme Court's declaration that it ought not to take place because the president checked the court and refused to implement their decision. And what we're going to find is that it's easier for the president to get away with these kind of things when he's popular and the court is unpopular, or when the court is making decisions that the public thinks is completely partisan or totally wacky. So the court does need to maintain public opinion for the same reason that the president wants to maintain a high approval rating. When the president or the court is unpopular, it becomes easier for other branches of government to justify checking the court. And I do want you to understand that aside from refusing to enforce or implement the court, the executive branch does have some other tools that it can use to check the court. And in particular, it can use what we call court packing. This was most famously performed by FDR, who loved to flood the court with justices that would basically issue whatever rulings he wanted them to do. Remember, the Constitution doesn't create any rules about how many justices must serve on the court. And so presidents have worked with Congress to pack the court by increasing the overall number of justices so that they can then hand-pick the people who will fill the new openings. Under FDR, for example, the courts repeatedly struck as unconstitutional many of the president's New Deal policies building up the modern welfare state. But the president wanted a welfare state, and so even though the courts had repeatedly declared his actions unconstitutional, he was able to get his way by threatening to pack the court. He got the Congress to introduce legislation which would have increased the number of justices from 9 to 15, allowing the President of the United States to handpick 6 new justices and permanently ensure that he and his party have a majority of the justices and therefore could control basically every decision the court made. Now, that would be a clear usurpation of the court's independence, but it's perfectly constitutional, and to prevent this hijacking, the courts essentially acquiesced to the will of the president. Again, keep in mind that FDR was only able to do this because at that time he had overwhelming public support as well as the cooperation from the Senate. So court packing isn't all that easy, but it is a way that the president can check the courts by filling them with a number of appointed justices who will rule in compliance with that president's preferences. In addition to refusing to enforce the decisions of the court or packing the court from the executive branch, there are also some legislative checks built into our Constitution. First, understand that Congress controls the power of the purse strings. And while they are not allowed to strike the pay of the justices or to lower that pay while the justices serve, they don't have to necessarily cover the benefits of the justices, and they don't necessarily have to give the justices any pay raises. So Congress can, at least theoretically, check the courts by threatening to deny them any increases to their wages or by threatening to do things like pay for their limo drivers. Congress has tried this. I do want you to note that the courts have generally been unimpressed because by the time you're on the Supreme Court, most people are already exceptionally wealthy, and this just doesn't make much of a difference to them. In addition to that, though, remember that the House doesn't have much say in the nomination process, but the Senate does. And so that court packing process that we just talked about also involves Senate participation. The Senate can, with a friendly president, also engage in court packing by confirming judicial nominees. Finally, and most importantly, we have jurisdiction stripping. Remember what I told you about Article 3 of the Constitution. It tells us that the court, the Supreme Court in particular, will have some very, very, very limited original jurisdiction. but that it will have appellate jurisdiction with such limitations and regulations as Congress shall make. That means that Congress has the power of jurisdiction stripping, the power to take the court's ability to hear certain cases away from it. Now, again, it can't touch that original jurisdiction without a constitutional amendment, but that original jurisdiction is so limited that in 99.9% of all cases, it's utterly irrelevant. 99 out of every 100 cases that the court hears is going to be heard on appeal, and Congress has, constitutionally speaking, the authority to take that away. In fact, one of our former presidential candidates, a character by the name of Ron Paul, had actually made a proposal to strip the courts of their authority over abortion cases because he felt that they had overstepped their constitutional bounds with a string of activist cases like Roe versus Wade, which protected abortion, even though it's not explicitly mentioned in the Constitution, and even though the framers probably never expected that the Constitution would be used in this way. His answer to this activism was to engage in jurisdiction stripping. He did not succeed in getting that legislation passed because, remember, Congress tends to be less popular than the courts, and Congress has to worry about that because it wants to get reelected. So jurisdiction stripping in practice doesn't happen all that often. It's occurred a couple of times in some very niche cases, but by and large, this is a bigger tool in theory than practice. And so, once more, I'm going to close this lecture by noting that overall, the courts tend to be regarded as the strongest portion of the federal government. And while there are some theoretical ways that the executive and the legislative branches of government can check them, they're not put into practice very often. All right, that's the end of our lecture. Y'all take care.